Welcome to the Consultation. My name is Josh Floyd, here with Christina Jimenez. We are licensed attorneys here in the state of Texas, both attorneys at Jimenez Floyd PC, Texas Family Law Firm, and
There's a lot.
there's a lot. Yeah.
So in case you didn't catch that, we have a new name. There'll be another video on that. So go ahead. And so we're here
today we're going to discuss conservatorship. Comes up a lot in cases, I think.
It does, absolutely.
Probably every one of them.
Yeah, not all of them.
All
if
the
there's no
involved children.
Yeah. So, as we say during the podcast, beginning, middle, and end, do not please construe this. Do not please
construe this.
Please do not construe this as legal advice.
Did you drink before this podcast?
Guys, it's 4:00 on a Monday and we're tired. So be ready.
Today's only Monday?
Today's only Monday. Okay, and so don't construe this as legal advice. If you find yourself in a situation where you are wanting to fight for conservatorship, find yourself an attorney who practices in your district. Go and consult with them. Tell them your situation and listen to their advice because they're going to be the experts on all of this. This is purely for informational purposes. And so,
do not try this at home.
Don't try it at home. So we are talking today about the difference between joint managing conservatorship and sole managing conservatorship. And you may or may not be able to see, but I have my laptop up. Excuse me. I have my laptop up. I have my family code out. And the reason is because obviously there's a lot of input that goes between or that we have to discuss as it pertains to conservatorship. Okay. And so let's talk a little bit about how this comes up. So typically when I'm on a consultation, a client will tell me, I want sole custody of my kiddo, or I don't want him to have any rights to my child. And so we kind of have to deep dive to figure out what the heck they're talking about. And most of the time I figure out that it's really not about conservatorship and they don't really know the difference between joint and sole and what all that entails. It's mostly that they're concerned about like visitation or a certain type of decision-making power. Yeah.
Correct. Yeah, and then we have to explain to them kind of what conservatorship is, right? It's completely different than possession and access, and they basically have nothing to do with one another, right? There are some presumptions that go back and forth between them, but I tell them, you could be joint managing conservator, but the other parent have supervised visits, right? Or you could have a sole managing possessory, but have a standard possession order, right? They're completely two different deals that we have to deal with. Conservatorship really is the parental rights and duties, right? Whether they have the ability to do certain things under the code. And so, yeah.
Easy breezy. So let's kind of start off with the presumption. So in the state of Texas, there is a presumption that both parents shall be appointed as joint managing conservators, right? And so basically that's where we're all starting off, is you should be a joint managing conservator of your child, unless the court makes a specific finding that
it's not in the child's best interest.
Right. And so when we're going through this, a lot of times parents are going to say, well, me and dad just don't get along, or I'm, pissed because dad cheated on me, or, dad lives 5 hours away. And so I'm going to, want to make all the decisions pertaining to the child, or what else have you heard? I don't
he spends too much time with his girlfriend, or whatever.
I don't like his new wife, things like that, right? And so anytime
I've been the one taking care of the child's whole life.
Right. He doesn't know anything about, the school or the doctors or anything like that. And so anytime I kind of start hearing those, comments during a consultation, typically my inclination is, okay, listen, we're going to start off at joint managing, and there is a very high probability that that's what the court is going to do if these are the only issues that we're dealing with, right? And so in order to rebut that presumption of joint managing conservatorship, to me, and I'm sure you probably feel the same way, it's a pretty high burden that we're going to have to overcome. And at least in my experience, the court is going to want to see some pretty significant evidence to say why you shouldn't be joint managing conservators.
Yeah, and we're going to go into detail, right? But basically, joint managing is you both have the same rights and duties, pretty much, right? And the public policy is, and the courts, believe that parents are going to make the best decisions for their child, or make decisions that are in the best interest. And so that's kind of where they start, right? They want co-parenting, they want both parents involved, and they want both parents to have equal rights. And so that's why that's the presumption, that's the starting point, right? And then the court's like, okay, tell me why this shouldn't happen. Why is this not in a child's best interest? And that's where the burden comes to overcome that presumption.
So the one way that is very common and that we see quite often to overcome that burden of joint managing conservatorship, or the presumption of joint managing conservatorship, is as it pertains to family violence. Okay. And so a lot of times when we're filing either a divorce case or even just a suit affecting parent-child relationship, we will be filing that concurrently with a protective order, right? An application for protective order where we allege some sort of family violence. Sometimes that is coupled with an arrest. Sometimes there's no arrest. There's just, evidence or testimony, photos, videos, etc. And so if there is a conviction of family violence in the 2 years preceding the filing or during, the pendency of the suit, or if the court grants a protective order and makes an affirmative finding of family violence, the code actually, that's when that presumption is essentially automatically rebutted, right? There's a code provision that says that the court shall appoint a sole managing conservator.
I don't think it requires a conviction, right? If there's been family violence within
There's
the
a
2 years
finding.
preceding. Yeah.
Yeah, right.
Yeah. Okay.
Okay. Yeah, if I misspoke, my apologies. But if there's just a finding of that,
Certainly a conviction would help, right?
right.
But not required.
And so when that happens, that's an automatic kind of SMC type situation.
Sole managing conservator.
Can I say, I'm going to say SMC for sole managing conservator. I'm going to say JMC for joint managing conservator. That's just the way that I talk, and I'm going to screw it up. So my apologies. So when we have that, that's kind of, it helps us if our client wants sole managing. What about instances of like child neglect, physical abuse, sexual abuse, things of that nature?
So you can use that to overcome, child abuse. So child abuse falls under kind of the family violence thing. Child neglect again too, sexual abuse, things like that, all falls under the family violence, where the court would be completely barred from naming him joint managing conservators.
Right. And so, but there's also other ways to do it too, right?
There is, yeah.
Which I'll admit that we don't see it a lot. I don't necessarily argue it a lot unless it's just like really, really bad. And so, things like co-parenting or an inability to co-parent, that is definitely something that can be argued, but the few times that I have attempted to argue that or have successfully argued that, I have really, really good evidence about the other parent just being completely just a jerk.
I think the times when I've been most successful is when the other parent just isn't involved, right? And not like one of those situations where, we were together and dad was the breadwinner, he was out working, and mom was a stay-at-home mom. Of course, don't really care about that, but what happened after separation, right? Has it been a year since dad has seen the child? Has he not reached out? Has he not attempted to develop that relationship and to be involved in a parenting situation with the child? I think that's where I probably see the most success for a sole managing argument.
But so I'm talking a lot about or the situations where I have a parent, and I've had this happen, where the parent was just completely blocking everything or anything that the mother was trying to do to care for the kiddos, right? So, if there was supposed to be a parent-teacher conference, he would somehow interfere with that. If there was doctor's appointments for the children, he would show up and he would cause a scene, and the kiddo had been basically kicked out from like 3 or 4 different providers because the father was just so difficult for these providers to deal with, and it was obviously having a significant impact on the kiddos. Where I've had situations where the father like curses out the counselors, those types of things. Or even I had a situation where during an exchange, almost every exchange, the father would throw something at or in the direction of the mother. And
That's not nice.
no,
For sure.
no. And so, thankfully or eventually the mother actually started documenting and recording all of this stuff. And in that particular case, which I didn't know that we would get sole managing, But in that particular case, the court was just very appalled by the fact that the father would do that while the mother's holding like a 3-year-old little baby at the time. He's throwing the kiddo's shoes at her. And so, judge was like, yeah. And I guess maybe that could have been a family violence type things that
And
is.
shoes are expensive
It's,
too.
yes, they
Throwing
are.
shoes.
But those types of things, like your ability to co-parent with the other parent, is something that the court can consider, but it really, really has to be significant.
Yep, it's
I
hard to
think.
prove for
Yeah.
sure.
So some of the other things that the court can consider is physical and emotional needs. Um, so I've had those situations in the past where the kiddos, I see this a lot, where the children have been diagnosed with like autism. And, maybe the other parent, like maybe the father or the mother, I've had it actually both ways where it was the father who was the only one that could really, calm the child or parent the child. And I've had the same thing where it was only a mother. And, it wasn't the other parent's fault necessarily. It's just, the way that things were. And that was a reason for them to be appointed as a sole managing, or it could be a reason for them to be appointed as sole managing. Um, what else? Anything else with physical and emotional needs?
I don't think so. I mean, there's a whole list of them, and I
Mm-hmm.
guess we're going to go through them, it appears. But and it's not just one factor by itself, right? The court considers all of these factors to make that determination because, like you're talking about the physical, emotional needs, right? You were talking about physical needs, right? The
Mm-hmm.
autism issue,
Mm-hmm.
because in that situation, they can still name them joint managing conservator,
Mm-hmm.
but make specific exclusive rights to one parent. So they're still joint managing, but give one a few more rights.
Right. Right.
So
So you also have physical and emotional danger. You have stability of a home. You have the plans for the child, cooperation between parents, parenting skills, who's the primary caregiver. And those are some of the factors that the court can consider. Um, we also have this stuff about false reports of child abuse, which we got to deal with
mm,
this morning.
we've been dealing with that a whole lot lately. I don't know what's going on, and we've already done a podcast on it, so we won't dive back into it. But
But
holy
I'm
shit, stop!
pissed. So, no, yeah. But that is actually something that the court can consider when appointing as joint managing or sole managing. There's also international child abduction, promoting or interfering with the relationship between the child and the parents.
Alienation.
Alienation is a big one, and I actually had a pretty big case a couple years ago. Um, and it involved, now that I'm thinking about it, the false reports of abuse, and also the parental alienation, where the mother just consistently, I think we had like 8 or 9 different reports to the department, and then we had different videos and audio recordings of this mother just bad mouthing the father to the children. And in that particular case, the court made an affirmative finding of alienation and appointed the father as sole managing. And so, we go through these factors not only to kind of explain how to get joint managing and sole managing, but also for you guys to understand the things that you should not be doing, right? And obviously, these things are
Making false reports.
they're not in the best interest of your children, which is why the courts can go through and consider these things to say, listen, you don't have the ability to do the right things for your kids. And so now, instead of you having all of this, decision making power over your children, I'm now going to strip you of what you were presumed to have, because that's where everybody starts, because you've chosen to act like a jerk and do bad things, right? So don't do the bad things. Think of your children at all times, and then everything's going to work out fine.
Yeah, again, it goes back to the courts want both parents involved, both parents making decisions, both parents working together for the best interest of the child. That's what they want to see happen. All of these factors just basically go to that. Like one parent can't do it or won't do it for whatever reason.
Right.
And that's when we look at a soul managing situation.
Right. And so, um, when you have joint managing conservators, typically you have one parent that's going to be awarded the exclusive right to designate the residence, and then the other one will have possession and access, right? When you have sole managing, you're going to be looking at one parent having the exclusive right to designate the residence, and typically the other parent will have some sort of possession and access. Okay. Um, there are instances in which the court can deny possession and access altogether. I think that's a podcast for another day.
Yeah,
Absolutely,
that's
because
a
we
whole.
could We could talk a whole lot about that. But you will typically, as a possessory conservator, as the sole managing conservator, or as a joint managing conservator, you will typically have the same rights to information. Is that how you explain those first 9 rights?
No, I usually explain it in a much better fashion.
How do you explain it?
So the way I explain it is basically the legislatures, they came up with this list of rights, and there's 2 main categories. I know there's duties and possession, but that's what I'm talking. 2 main categories. You have all of your information rights, and then all of the decision-making rights.
That's what I just said. The first 9 rights were
However,
information rights.
Under a joint managing conservatorship, both parents have both sets. Under a sole managing, one parent has both sets. The other parent only has the information rights.
So what I say is
not nearly as good as what I say.
No, but I always talk about the fact that in both scenarios you're going to have information rights. We're saying the same thing. We're just saying it differently.
I say it better.
But I think mine's better. But we're going to say it 2 different ways.
Vote
just
below
because
in this comment.
There's going to be a poll. No. So I always start off with the 9 information rights because that's the way the temporary orders and the final orders typically read. They start off with the information rights. And so the first is the right to receive information from any other conservator of the children concerning health, education, and welfare of the children.
That's correct.
Okay. Good?
Yep.
We're going to move on.
That's pretty self-explanatory.
So here's what I always say on this particular one, is I say that the litmus test is if it's something you would want to know, then you need to be telling the other parent about that. Right? And so if you would want to know that your kiddo had 103-degree fever that has lasted for 24 hours and they're going to rush them to the ER or to the, urgent care or whatever, then that's probably something that you should share with the other parent, right? If the kiddo has some sort of an infection or got bit by a dog or, got sent home from school because they, punched another kid in the face, those are the things that you need to tell the other parent. And it is beyond me when I have clients or when the other parents are withholding this important information from the other parent. And I'm telling you, it pisses these judges off, right? Like, hold on, you went and I had a parent who took the kiddo overnight to have a sleep study conducted so they could determine whether or not he needed to have his tonsils removed or was something like that. And my client knew nothing about it. And that was just appalling to this particular judge, because how are you going to do that and not share that?
Yeah, I generally hate the question of, do I have to tell them X? Like, why is it a burden? Just tell them. Right. Could you get away with not telling them? Maybe.
Right.
But why go down that trail?
Right.
I mean, just tell them.
Yeah. And we just had a case, a few weeks ago where so the father was coming in on a temporary basis to try to take the kiddo away from the mother, and he was alleging some sort of medical neglect. And through the cross-examination, we learned that he had actually taken this kiddo to all these different doctor's appointments to get all these diagnoses, did not tell mother about the doctor's appointments, did not share the diagnosis with the mother until such time as he filed an affidavit trying to take these kids away, or this kid away. And when that all came out, the judge was not happy, because that's important information that should have been shared with mom. You don't get to not share it and then try to use it against her, right? So just share the information, right? There's some really cool apps if you just don't like talking to the other parent, and I know that those are definitely situations that people deal with. So there's an app called OFW.
Our Family Wizard.
Our Family Wizard. You can sponsor us. App Close is also another one, right? OFW. And so those are really good apps, and they're called co-parenting apps.
Did you say App Close?
I did say App Close.
Yeah.
And I'm sure that there's other, but those are the 2 that we primarily use, or our clients use. And it's really cool because you could go on and say, hey, I just want to let you know, kiddo woke up with 102 fever, gave her some Tylenol, I think she's cool now, just wanted you to know, right? Or, hey, took them to the doctor and this is what they want to do. Just, here's the next appointment. Make sure if you can be there, be there. those are the things that are going to be, really, really good for you when you go to court if you do that.
And I know it's really hard to do when the other person's being a jerk, right? But always be the good guy,
Mm-hmm.
right? Overshare information, even if they're being a jerk, not responding, still do your part. That when we go to court, you're in a good position. The other person's a jerk. But if you start being a jerk also, now both of you are jerks and the court doesn't care.
Right. Right.
Well, I
So
mean, the court cares that you're both being jerks, but
I'm not going to care about your position.
Right.
So the next one is the right to confer with the other parent to the extent possible before making a decision concerning the health, education, and welfare of the children. Um, and so, I kind of laugh because it's to the extent possible, right? Sometimes you're just not going to be able to talk to the other parent, and we get that. Like, we're not, we don't have our blinders on. We know that it's sometimes super, super difficult. Um, but again, like Floyd says, if you're going in and you're doing the right thing, and then they come off as being, assholes, then that's on them, and the judge is going to see that, right?
this right always confuses me, right? So it says that I, Josh Floyd, have the right to confer with the other parent,
Mm-hmm.
right? It doesn't say that the other parent has the right to be conferred with,
Mm-hmm.
right? It just says that I have the right to call them and talk to them about it.
Mm-hmm.
Of course I do. I call and talk to anybody I want.
Mm-hmm.
So I don't really understand that. That right's confusing me.
The right to confer with the other parent to the extent possible before making a decision concerning. So before you, Josh Floyd, make a decision as it pertains to your child, you have the right to talk to Mrs. Rochelle Floyd, or I guess Miss, if y'all were doing this, Rochelle Floyd, before you made a decision regarding health education.
Of course I do, right? But
Right.
it doesn't say that Rochelle has the right to be conferred with by me.
Right. I guess that's true. Okay, so
It's just telling me that I have the right to
call.
call and talk to somebody about it. Yeah, no.
And you should, though. I think
It
that's
doesn't
the
say that.
point. I
Doesn't
know,
say that.
but you should, right? Please do.
It doesn't say you
Um,
should confer. It says I have the right to.
And so this is another way, though, that I see people getting in trouble is they go and they make these major decisions. They're pulling kiddos out of school. They're, making major health decisions for the kiddo, and they're not talking to the other parent before they do it.
Right.
Right. And so just make sure that you're doing it. And so even though, let's just say hypothetically speaking, that you call the other parent and you say, listen, I took the kiddo to the doctor and kiddo needs to have his tonsils removed. And the other parent says, well, F you, I don't agree. I'm not going to, do this. Or I'm not going to give you my consent. Then, what I would typically say is we'll give them the doctor's information, give them some time to confer with the doctor. And then if they don't take the steps to talk to the doctor, maybe get a second opinion, I don't think a court would hold that against you if you move forward with that procedure, so long as you're sharing the relevant information.
Yeah, and certainly if it's something that's recommended by the pediatrician.
Right.
Right.
Right. So next is the right to access medical, dental, psychological, and educational records of the children. Okay. So I had this happen a whole bunch of times in my cases where sometimes they have a prior order, right? And in this prior order, typically will say that they have the rights to get this information. And lo and behold, my client goes to the school to try to pull the attendance records because, they're thinking there's some things going on. And the school says, oh, well, sorry, we can't give you these records because you're not on the paperwork. Or the doctor says, we can't give you this information. I always instruct them, take your order, show them your order, show them on this page where it says you have this right. And they should, at that point, release the information to you.
Does that ever work for you?
It has worked for me several times. No?
A couple times I've tried it. I get a call from the principal or something. They're like, well, the order says this, this, this. It doesn't say this, this. I'm like, nah, no, the order says you have to give him the stuff. And they're like, well, I'll have to refer to our attorneys.
I feel like you need to just call me, conference me into that bad boy. I got you.
Yeah, sometimes they can be pretty difficult.
No, I've never had that issue before.
Yeah.
Yeah. So you have that right. So I always tell them take the order. So right to consult with a physician, dentist, or a psychologist of the children, pretty easy. You can talk to your doctors. The right to consult with school officials concerning children's welfare and educational status, including school activities, also pretty easy. You can talk to doctors, principals, teachers, etc. Regarding the kiddos. So this one's newer, right? Didn't used to be the right to attend school activities.
Correct. It was just generally the next one that encompassed the activity stuff.
Yeah, so the right to attend school activities, including school lunches, performances, and field trips. And so this one,
It's tricky.
it's always tricky. You can talk about it?
Sure, we can talk about it. So the portion of this, so to clarify, these are rights of parents at all times, right? And so if a parent has supervised possession, can they go eat lunch with the child at school?
I thought you were going to talk about it.
I don't know.
You're not saying anything.
I just had an answer. Right?
So typically what I will do, and I don't know. So typically what I think that you could do in that particular case, if the parent only had the supervised possession and access, is I typically will add in like something that says solely in conformity with the possession and access as
Subject to
stated
the
here.
provisions below,
Correct.
right.
And so I will typically put a caveat in there, because my position is if the court is saying you can only see these kiddos at a facility for a couple of hours each time, they don't want you going to the school. They don't want you going to school to lunches, performances, and field trips, right? Now, I would say that on the times when my client is afforded supervised possession and access, that is something that I clarify, because I have had judges who will say, no, they can go to school activities. They just can't actually take possession of the child, right? If they're at school or if they're at lunches or if they're at these performances, they're in the crowd and they're watching. And so I don't believe that that is a danger to the children. They can be there. I just don't want them having sole possession of the kiddo and the ability to remove the kiddos.
Yeah, and that's really fact dependent situation, right? Because if the danger is, you got one parent, that's doing drugs and stuff like that, and therefore is a danger to the child based on that kind of stuff, right? If they're in a public environment, the chances of the child being injured are not that great because somebody will see it and stop it, particularly in a school environment. But if the danger is talking crap about mom or telling the child inappropriate things, stuff like
or
that.
Physical abuse, sexual abuse, those types of
right.
things.
Yeah, stuff when they're seeing the child that would cause the child emotional harm, right? To have to see them after something like that. Then the court's more likely to say, no, you don't need to see this child at all except for in the supervised facility. So,
as always, thank you guys so much for listening to us, for watching us. We appreciate the support. Find us on any social media platform that exists: TikTok, Instagram, Facebook, YouTube. Like and subscribe. Again, this is not to be construed as legal advice. Find yourself a good attorney that you feel comfortable with. Tell them your story and then listen to them.